Well, so after months of heated public and legal debates, the Supreme Court has brought closure to the matter of voting rights of a deputy speaker. The court, in a unanimous 9-0 decision, ruled that its decision that allowed a deputy speaker to vote while presiding over proceedings is valid. Private legal practitioner Justice Abdulai, who found the matter, had wanted the court to set aside its judgment, saying the judges got it wrong. Well, the judges disagree with him. Court correspondent Joseph Abdulai has the rest of the story.
Mr. Abdulai had argued the court's March 9 judgment ignored legislative antecedents of the voting history of deputy speakers in Ghana. He added that failure of the ordinary bench to consider portions of Ghana's constitution and the Parliament Act of 1965 meant the court got it wrong. Deputy Attorney General Diana Sunaba Dapa disagreed. She insisted the review threshold had not been met, a position the court upheld, dismissing the application for review. The Deputy AG is not surprised.
The review application is very strict and the grounds clearly stated, and one needs to find his case within the threshold set for a review application, that exceptional circumstances which has occasioned a grave miscarriage of justice, and there are new information that has been discovered which was not present at the time of the determination. I do not think, even without going through the review application, any argument advanced by the plaintiff on the basis that the court ought to have had regard to previous constitutions and other statutes of the Commonwealth will still have held. As you clearly heard, our constitution, which is a written one, is sui generis and ought to be interpreted in accordance with its peculiar nature. And so reference to other constitutions, even previous constitution, is no basis.
Mr. Abdulai says the odds were up against him.
Prior to today, I had made it clear that a review application is probably one of the most difficult things to succeed in at the Supreme Court. And so I knew the odds were against me. Indeed, some had predicted 1:100. I had predicted almost 0, except that I still moved forward with this because, in principle, as I said, I believe that the Supreme Court is made of seasoned lawyers, and if you make strong arguments before them, they were amenable to reviewing their decisions, their previous decisions. As it turns out, they decided otherwise. And once they've decided otherwise, I think we have to move on as a nation. What I didn't want was a situation where posterity would question us.
This brings an end to the dispute over the voting rights of a deputy speaker. For Joy News from the Supreme Court, my name is Joseph Abdulai.
Well, so that's the update from the Supreme Court. It's clear now that the Supreme Court will not vary from its earlier ruling on the matter. But what does the man at the center of all this think about the ruling today? Joining us now is Justice Abdulai. He's a legal practitioner. Thank you, sir, for joining us here on the poll. So for many, this is just a waste of everyone's time. Is that what you think as well about today's exercise?
Absolutely not. And I think that would be unfortunate if that is the thought of anyone, to think that going to the Supreme Court is a waste of time or resources. I think that is not a nationalistic thinking. It's not a patriotic thought if that is how a person looks at things of this nature.
In fact, what's instructive is that you admitted that when you granted an interview to Joy News after the ruling today, you told us that the odds were against you. It presupposes that you were in for an exercise in futility. That it was as simple as that, isn't it?
That is a wrong assumption. It is rather the case that I admit that going for a review was a daunting task. The odds were naturally against me. That is not to say that what I was going for was an impossibility. But assuming that was even the case, it reaffirms the position that once there was a window of opportunity, it's common sense would dictate that, considering the nature of the judgment, I take advantage of that window of opportunity, just so we would all be on the safer side of posterity. If judgment was passed on us, that we did everything that was within our rights to ensure that things were done for this country the best way we could. But this was the outcome of those decisions that we took. And I think given the opportunity 100 times, I'll take the same decision 100 times.
Interesting. And what exactly was your expectation? You were expecting that the Supreme Court judges would admit your concerns? There are two issues actually, on the quorum and on the approval of the budget. Particularly, where were you, placing your hopes that at least would have a leeway from the Supreme Court?
I wasn't going for a list because I as far as I know, I made a very good case, a strong case for a review of the decision. But my views are not necessarily the views of the Supreme Court. If you read the application for review, whoever has read it would tell you that it was a well-researched and well-thought-out application that was filed. But we should all remember that the Supreme Court operates with two main principles, particularly guiding it when dealing with review applications. That one of which is to ensure that they do not open a floodgate for reviews, and the second being that they do not want to use a review application as a way for losing parties to really, in fact, an appeal to be used as a cloak for a review. So the idea is to narrow the route for a review. And you go through the law books, you find that review applications seldomly get positive responses from the Supreme Court. But that is not to say that it's an impossibility. It was worth the fight. It was worth every single minute of my time and resources. And as I've indicated,
well, you don't sound like the usual Justice Abdulai. Are you discouraged by the ruling that we're seeing today from the Supreme Court?
I'm sure you can see that I'm very tired.
Well, but you tell me that what you've presented before the Supreme Court was a well-researched document. What was different from the argument you were making earlier?
It is not the differences in the argument. It is the flesh and the amount of the volume of authorities that re-emphasize the position that the Supreme Court erred in their previous decision, and judging by the various authorities around and what we are used to from the past all the way to today. And so and there are a plethora of authorities, and indeed in the Constitution provides yet further authorities that giving a more holistic view, I strongly believe that the Supreme Court would have had judgment in my favor. But this is what they believe, and I think that once the Supreme Court has spoken, there is no any other means of getting the decision reviewed or reversed unless a different matter goes before the Supreme Court. For instance, like the case of the Haruna Idris of the Attorney General, if it goes through the merit, possibly, or in future, if any other case goes before the Supreme Court, they have the complete authority to depart from Justice Abdulai as Attorney General and come up with a new decision. So it's not all lost yet, but as to when, that is
we'll see about that. But in fact, the grounds on which you're challenging the Supreme Court has two legs, particularly when you're looking at it from the aspect of the empirical evidence. It appears that the Supreme Court has quite a sound reasoning, admitting without, necessarily siding with the Supreme Court on this. The fact that if you look at the membership of Parliament, there's a need for the Deputy Speaker to represent his people. And that was part of the legal reasoning of the court. So why do you disagree with what some experts have described as a strong position by the Supreme Court?
I do disagree on that, not on the basis that I'm saying that they do not have the right, but I think it's because we have miscalculated that particular position or misjudged it. My position has always been very clear that so long as you are presiding, that's the time that you lose your voting rights. And that is not the only instance that the person loses his voting rights, even though they still represent their constituents. I think we should be very clear in our minds that there are several instances where members of parliament lose their voting rights. And being a deputy speaker is just one of such instances that I think that member of parliament should lose his voting right. Remember, that's the member of parliament when once he becomes a deputy speaker, does not only lose his voting right, but he also loses his opportunity to be a minister of state. Why are they not complaining about that? Because they admit that a speaker cannot be a minister of state. If a speaker cannot be a minister of state, and what circumstances can a speaker then be doubled as a member of parliament at the time that he's speaking, at the time that he's acting as a speaker of parliament. So the position, however, and then remember that the black and white law that have stated categorically under the Parliamentary Act that a member of parliament, once you're acting or presiding, you cannot retain your original voting rights. This has always been the law from 1957 all the way until 1967, thereabout.
If you look at the implications of what you're asking the Supreme Court to do, for instance, there's the argument.
What I asked, because we are no longer before the Supreme Court.
Okay, I get that very clearly. But if you look at the argument about proportionality, does the concern about the implications of what you're asking or were asking the Supreme Court to do, the fact that that would have obviously implications not just for the 2022 budget, but also some of the issues that we've gone past, for instance, the controversial subject of the electronic transactions levy. Were you mindful of all of these sets of facts before proceeding to the Supreme Court?
Indeed, I was mindful of that, but that would be a short-sighted way of looking at events, particularly of the law. You do not just take into consideration just an event of today to make a decision that has a far-reaching consequence on our entire nationhood. That is a wrong way of looking at things. Building a nation and in making laws do not take into consideration simply the events of today. It has to take into consideration the past and the future, not just today. You do not confine yourself, imprison yourself particularly with regards to constitutional matters. And that is why we always have said that the Constitution is a growing document because it has to look into the future and not confine itself to matters of today.
The argument, finally, is that you have another opportunity. At least you may not be a party to that case, but we know that some members of the minority side of Parliament are heading to court over another issue, demanding some interpretations on the quorum and asking for the ultimate halt of the electronic transactions levy. Is that another moment where you believe that the Supreme Court will vary its decision on matters?
I do not believe that at all. Even though it's an opportunity, but we should remember that almost every constitutional matter is an opportunity for the Supreme Court to depart from their decision in the Justice Abdulai Attorney General's case, particularly when it borders on those issues involving Parliament. So it's not as if the Supreme Court is really boxed in a way that they cannot come out of that. Except that rather than granting a review application, that's the route the Supreme Court would always take. They rather have a fresh case and use that fresh case to depart from a previous decision, unless they are so convinced that maybe they should grant it. And if you check our law books, the instances where the Supreme Court have granted this are very few. And so, yes, to that extent, I would say that there is indeed a possibility that the Supreme Court may rely on the Haruna Idris as Attorney General to probably depart from Justice Abdulai. But that is a completely remote under the circumstances because we do not have the argument of Haruna Idris or the Attorney General at hand at the moment. We only have the benefit of the writ and the relief they seek. And those may not be enough to make any value judgment of the present circumstances.
Is this the end of the road?
To the extent of the issues of parliamentary voting and quorum formation, this is the end of it. This is the new law. This is what we have to accept. We all have to embrace it, and we have to make the best out of it. We probably have to engage ourselves more often dialogue more often, and see how best we can come together as one nation and put our differences aside and see how best we can make better use of this new law, this new phenomenon. I think it is the best way we can win as a country and not necessarily fight each other. Of course, unless the fighting and the scuffles going on are part of the growing processes. Sometimes, as part of the growing process, we go through some of these difficulties. And so we evolve. And I expect that the evolution would see less of the scuffles that goes on in Parliament and more of dialogue and commitment to nationhood and possibly citizens' patriotic participation in nation building and demanding accountability and ensuring that we get the best out of our leaders. I think this probably may be the best way out of this whole event. But of course, we should always expect that I would always be a citizen. That is what I would want to do for this country.
Well, we'll have to leave it here. Thank you so much for joining us. That's Justice Abdulai. He's a private legal practitioner.